The American ethos often holds up property rights as one of the most sacrosanct tenets of personal freedom. Yet, a closer look at the Constitution reveals a far more nuanced picture. Rather than an absolute right, property ownership in the United States has always been subject to limitations, viewed through the lens of privilege rather than an inviolable entitlement. The Founding Fathers and subsequent legal interpretations by the Supreme Court have emphasized that property can indeed be seized by the government under conditions sometimes devoid of what we might consider due process. This approach to property rights leaves room for governmental intervention and confiscation under specific circumstances, casting ownership less as a fundamental right and more as a privilege bound by certain expectations of lawful behavior and public welfare. Constitutional protections and their limits. The Fifth Amendment of the Constitution, often cited as a cornerstone of property rights, states that no person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. However, this language does not absolutely guarantee property rights. Rather, it establishes procedures for property to be taken, implying that ownership can be overridden under the right circumstances. This legal precedent became formalized through the power of eminent domain, where the government can seize private property for public use if it provides what is deemed fair compensation. Over time, courts have broadened this power, allowing not only for traditional public works projects, but also for economically motivated seizures, as seen in the 2005 Supreme Court decision in Kello v. City of New London. In that case, the court held that private property could be taken for economic development if it would ultimately benefit the public. This landmark decision emphasized the extent to which property ownership in the United States is conditional, subject to the government's judgment of what best serves the broader community. Historical examples. Property as conditional ownership. Throughout American history, property confiscation has been applied to individuals deemed harmful to the public. A prominent example is the government's use of the Racketeer-Influenced and Corrupt Organizations Act, RICO, to target organized crime figures. Under RICO, assets linked to criminal enterprises, including properties and businesses, can be seized without the usual due process protections afforded to the average citizen. For instance, mafia godfathers who accumulated wealth through illegal means saw their assets forfeited to the state in an effort to dismantle the criminal infrastructure and limit its societal influence. This strategy illustrates the government's commitment to neutralizing power that, while legally possessed, is seen as fundamentally harmful to the public. A more recent and notorious example is the case of Jeffrey Epstein, the financier and convicted sex offender whose property holdings were targeted following his arrest. Epstein's assets, including his luxurious private island, were seized and sold, with proceeds directed toward victim restitution. Epstein's case is significant because it reveals the government's resolve to strip those who violate societal trust, and in this case, the law, of their resources. His property was not protected as a sacred right, but rather as a privilege forfeited through criminal misconduct. These cases underscore that while property ownership is recognized in American law, it remains conditional on its responsible use within legal and ethical boundaries. When fines aren't enough misuse of wealth and privileged property. These cases naturally lead to a pressing contemporary question: should billionaires who misuse their extreme wealth to harm, defame, or coerce others be allowed to retain their property without significant repercussions? Wealth that is weaponized to harass or manipulate society cannot reasonably be countered with mere fines, especially when those fines represent a negligible fraction of the individual's assets. Fines, by their nature, fail to impose meaningful accountability on the extremely wealthy. They serve as minor setbacks rather than genuine deterrents. Consider, for instance, cases where billionaires use their wealth to silence or retaliate against critics, spread misinformation, or exert undue influence over public policies for personal gain. When fines fall short of reining in such behavior, the argument could be made that property confiscation, as a consequence of abuse of power, should become an option. property at such extraordinary levels of wealth could be viewed as a privilege tied to responsible stewardship of influence. This perspective would align with the precedent that ownership, particularly when it involves public influence, is a privilege dependent on lawful and ethical behavior. A caution against overreach. While this approach might offer a potent means of addressing abuses by the ultra-wealthy, it also necessitates caution. History provides ample examples of property confiscation being abused for political or ideological purposes. The McCarthy era, with its witch hunts and arbitrary confiscations, exemplifies the dangers of overextending this authority. Should property seizure be used as a punitive tool against the extremely wealthy, a rigorous legal framework must ensure that this power remains fair, transparent, and balanced. Clear limitations, judicial oversight, and public accountability would be essential to prevent the pitfalls of arbitrary enforcement or politically motivated actions. Conclusion: property as privilege, not absolute right. The notion that property is an inviolable right is, in many ways, more myth than reality within the American legal framework. From the Founding Fathers to the present, property has been treated as a privilege that comes with conditions. This perspective has allowed the government to revoke property ownership under specific circumstances, reinforcing the view that ownership at its core serves public welfare rather than solely individual benefit. As modern society grapples with the unprecedented influence of billionaire elites, revisiting property rights as a privilege could serve as a balanced approach to ensure wealth is wielded responsibly and that abuses of power face more than a token fine. The message is clear. Wealth, particularly when it intersects with public welfare, is a responsibility, not an entitlement. By reinforcing the conditional nature of property ownership, society can hold those who wield extreme wealth accountable, reminding them that their influence is indeed a privilege, not an absolute right.